are these people?
We've got journalists literally that are getting locked up right now. And the first one is someone that we may not necessarily even agree with always. And that's the thing, is that they're coming for journalists on both sides. Wow, that's really loud. And I hear echo.
I'm sorry.
Kevin Gosztola, Indie Media Award honoree for the Dissenter. Okay, judge holds former Fox News correspondent in contempt for protecting their source. Another crazy story. So what happens? I really hear a big echo here. I don't know what's pumping. But so a United States judge has held former Fox News correspondent Catherine Herridge in civil contempt for refusing to reveal the identity of a confidential source who allegedly committed a Privacy Act violation against Chinese-American scientist Yanping Chang. Okay, so what happened? The court imposed a fine of $800 per day until Herridge complies with the order, but stayed the decision to give Herridge an opportunity to appeal. So that's at least, like, nice, maybe, sorta. At least letting her appeal and staying out before she avoids this. But last August, Judge Christopher Cooper, the U.S. District Court for the District of Columbia, upheld a subpoena against her. He concluded that Chen had overcome the qualified First Amendment privilege in this case. Okay? And then Caitlin Vogus, who's the deputy director at Advocacy at Freedom of the Press Foundation, said that the court's order should disturb anyone who cares about press freedom. And Kevin himself, I messaged Kevin about this, and I told him we were covering this story tonight, and he said, I don't even necessarily agree with what she covered, but she certainly should not be held in contempt for not revealing a confidential source. So the court imposed a worryingly high fine on Herridge and threatened to revisit both the amount of fine and its decision not to forbid others from funding Herridge's payment of the contempt sanction, right? Depending on how things play out after any appellate proceedings. What? Like, again, they reserve the right to screw with you at any moment. At least that's what I'm reading. Reef, are you seeing this?
Yes.
All right. The only reason Herridge defied the court's order in the first place is because of the Court of Appeals refused to allow her to appeal until she'd been held in contempt. It's appalling that the court would treat her in such a severe manner for simply following the instructions of a higher court. It really doesn't make much sense, right? Indeed, Herridge attempted to appeal the court's August decision, which upheld the subpoena, but the court refused to allow an appeal because there had been no contempt ruling. Again, it's like...
Who are these people?
That worked out with Kofi. Kofi did a thing.
Hey, look at that. Care Bear, yay. Okay. We just got it, yay. Okay, new donation from Care Bear. Check that out. All right. We'll have to show that at the end. Indy's back. Tell a friend. Yay, $5. Thanks. All right. DC Circuit Appeals Court later agreed that Herridge could not appeal, which prompted an objection from the Reporters Committee for the Freedom of the Press, which I've never heard of, which is weird.
Yeah.
Courts recognize that First Amendment harms can occur even before someone has actually been sanctioned for their speech. They can be deterred or chilled from speaking because of a regulation or enforcement action, and that in itself is an actionable injury. Hard to argue with there. Herridge argued that requiring journalists to be held in contempt before they can challenge court orders requiring them to hand over source information is incongruent with the way that courts think about First Amendment harms. You can't, right? It doesn't align, all right? Because if you have to be held in contempt before you can even challenge the court order, that puts you in a really difficult position to begin with, right? So Hockett continued, we agree that journalists should not be forced to subject themselves to a contempt citation in order to challenge a court order to turn over source information. And all these press freedom groups have unequivocally opposed the subpoena against Herridge, yet Cooper questioned the notion that forcing her to reveal her source would do irreparable damage to freedom of the press. I don't see how he can make that argument, but as they previously summarized, this case stems from Chen, who's a naturalized U.S. citizen. I don't think that really has anything to do with it. She was the founder of the University of Management and Technology, which is an institution that attracted a substantial number of military service members who attended with tuition assistance from the DOD. Okay, again, you may be mad about that, but that's legal and perfectly within her rights. So I don't know why, again. The FBI targeted Chen in 2010 after agents became concerned about statements that she made on certain immigration forms about her work in China in the 1980s. So now all of a sudden they think that this woman,
FBI, open up!
right? They think that this woman's a spy. Search warrants were executed by the FBI at Chen's home and her office at UMT. Materials were seized, but prosecutors later indicated in 2016 that no charges would be filed. Which again doesn't necessarily mean that they didn't suspect something. It meant they couldn't prove anything in court, so they wouldn't file any charges. Because if they could prove it, you could be sure they would have. Right. If you could, you could be sure they would have if they could have proved it.
Yeah.
Right. So in 2017, Fox News aired several television segments and published multiple articles that focused on Chen's alleged ties to the Chinese military and former role as a colonel in the People's Liberation Army. So
PLA?
that would be the one and the same, right? Herridge also authored an exclusive report headlined Fox News Investigation, DOD-funded school at center of federal probes over suspected Chinese military ties. Basically, she got this wrong, all right? And now they want to come after her and say, who was your source? Well, that's protected still, even if she got it wrong.
China.
Right, well, that's who they think it is. The thrust of the stories, according to Cooper, was that Ms. Chen had concealed her former membership in the Chinese military on her U.S. immigration forms and might have been using a professional school she founded in Virginia to funnel valuable information about the American military to the Chinese government. It's such a ridiculous reach. It's such a ridiculous reach. Come on, man. Really? I mean, really?
Really?
Why?
Family photographs of Chen, excerpts from Chen's immigration forms, and a snippet from what appears to be an FBI memorandum summarizing an interview conducted for the investigation were allegedly leaked by U.S. government officials in violation of the Privacy Act. Huh? Yeah, we've never seen anything like that happen to somebody that might be under investigation, right?
Nope.
The reporting allegedly played a role in the decision made by the DOD to terminate UMT's participation in the tuition assistance program that helps military students pay for classes, and that resulted in substantial financial losses for Chen. Well, that makes sense. If she's making money off the Defense Department training people, and that program ends and she no longer makes money off the Defense Department training people, that's going to incur substantial financial losses, I would imagine. Cooper then maintains that the images of Chen holding or wearing a Chinese military uniform likely helped the reports about the FBI investigation gain traction. Were the photographs here irrelevant? Moreover, the court wonders why Herridge would have thought to include them in her reporting, notwithstanding the obvious legal implications of doing so. And let me answer, she worked for Fox News. They were fear-mongering Donnie's favorite place on earth, China. All right. She was looking no, not Obama.
Wrong one.
China.
That one. Yes.
Yeah.
In justifying the court's decision, Cooper emphasized the absence of federal law that enshrines a news-gathering privilege for reporters. He suggested Congress could pass a law with few strokes of the pen and protect Herridge. Yes, well, maybe, but yeah, good luck getting Congress to do anything to protect the press today and journalists. Come on. Julian Assange, there's a guy named Julian Assange? Free Julian Assange.
Yep. As
Sam Somerson also said here. Thank you, Sam. Welcome. Of course, the lack of a federal shield law does not mean that courts should apply the First Amendment reporter's privilege any less strictly. But the court's decision here is all the more reason that Congress must pass the Press Act, which would establish in no uncertain terms that the court cannot compel Herridge to reveal her source. I've heard some weird stuff about the Press Act too, but I've heard overwhelmingly positive stuff, though there are, I believe, some drawbacks in potentially opening up ways to impact journalists negatively.
Okay.
I got to look more into that. I want to look more into the Press Act, and we need to do that. So Herridge provided the court with declarations from Jelani Cobb, who is the dean of Columbia School of Journalism. That's like one of the top journalism schools in the world. And Steve Call.
Journalism school.
Well, yes. Northwestern has Medill, and Syracuse has Newhouse, and Columbia has CJS. Those are like the three of the top journalism schools. And how do I know? Because I wanted to originally be a journalist in high school, and then I got the deadlines, and I said enough of that. But anyway, Steve Call is a Pulitzer Prize winning national security journalist, right? Both called attention to the chilling effect that holding Herridge in contempt could have on investigative journalism. And there was also an amicus curiae brief submitted in opposition to the court by RCFP. So, referring to judicial precedent that allows courts to compel reporters to reveal their sources, Hooper brushed aside concerns. Any marginal chilling effect has certainly not frozen the information pipeline. Instances of journalism built on confidential sources remain legion. Yes, but if the court can compel a reporter years later to have to reveal a confidential source, don't you think that might stop people from doing some investigative journalism with confidential sources
or
today? Yeah. All right.
Mm-hmm.
Bogus scoffed at this assertion here. Any journalist knows that being able to promise whistleblowers and other sources confidentiality and being able to keep that promise is crucial to reporters' ability to win sources' trust and report the news. When courts force journalists to burn their sources, it is absolutely undermining the public's right to know, which sometimes the courts don't necessarily care about. They're supposed to, but do they? No. Well, yeah, not so much.
Only when it benefits them.
Well, yes, exactly. So for sure,